back on the record in cause number M31372. Let's see. 724. Yes, M313724. The court had an indigency hearing. The court is going to find that you're indigent, and that's pursuant to Article 42.15 Texas Code of Criminal Procedure. And based on that finding, the court calls in this case will be waived. So, Ms. Vital, the state is offering that you serve 10 days in Jefferson County Jail. You'll be given credit for the time that any time that you're entitled to get by law. The court cost in this case is going to be waived because the court has found that you're indigent. And the court is going to back up and go to, well, first of all, do you understand the state's offer in this case?
Yes, sir.
And do you also understand the court's finding?
Yes, sir.
Okay. Now, do you accept the state's offer and the court's finding?
Yes, sir.
And just for the record, this case, you'll report to the Jefferson County Jail on June 23rd of 2023. And this case will run concurrent with cause numbers 313722 and cause number 313726. Now, do you understand the state's offer?
Yes.
And the state's finding?
Yes, sir.
And it was the court's finding? And do you think that it's fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, the court is going to follow the plea bargaining agreement that you have entered into with the state. And just for the record, the court is also, since the court has found that she was indigent in this case, the court will find that she's also indigent in cause number M313722. And so the court costs in that case will be waived. The indigent. Okay, now, Ms. Vital, the court is going to move to your next case. And the next case, 726, I have before me a motion to revoke your probation. And in this motion, it alleges that you, Danella Marie Vital, on February 6th of 2018, that you were found guilty for the Class A misdemeanor offense of assault, family violence. Your punishment was assessed at 90 days confinement in Jefferson County Jail and a fine of $100. Your confinement portion was probated for a period of 12 months. In this motion, the state has 3 allegations. The state is abandoning allegations 1 and 3. Is that correct, state?
Correct.
And therefore, they only are proceeding on allegation 2. Allegation 2 alleges that you, Danella Marie Vital, failed to perform the community service hours as required by the court in violation of condition 14 of your probation law. Is that true or not true? Now, are you pleading to the allegation number 2 freely and voluntarily?
Yes, sir.
And are you pleading true because it is true?
Yes, sir.
Okay, thank you. Now, Ms. Vital, I have before me State's Exhibit number 1, which is the misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 3 of the same document, there's a set of initials on the line next to the box that check MTFE, which means motion to revoke probation through the allegation number 2.
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defense Right Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Mhm.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Ms. Vital, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1, state you like to offer State's 1.
Yes, sir.
No objection, State's Exhibit Number 1 will be admitted. And again, Mr. Cole, you've advised and counsel Ms. Vital, is there any evidence that she is currently mentally incompetent to stand trial?
No,
And Ms. Vital, your attorney has advised and counseled you satisfied with his representation in this case.
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Okay, Ms. Vital, I accept your plea of true to allegation number 2. I will find that you're pleading away with the feeling voluntarily given. I'll also find that there is sufficient to revoke your probation, and your probation is hereby revoked in actually all 3 of these cases. And Ms. Vital, well, State, do we have a punishment recommendation?
And I state, transported to judicial notice of defendant's pleas true, find them true, which you have. And an agreement, we offer 10 days in county jail. Sorry, it's been a long day, Joe. 10 days in county jail. Court call, same record current with the 2 previous charges. She will report on June 23rd
Okay,
or 6 p.m.
okay, well, I think that woke Ms. Vital up. Okay, so Ms. Vital, State is offering that you serve 10 days in Jefferson County Jail. You give him credit for any time that you entitled to get by law. The court costs, in this case, $67. However, the $67 court costs will be waived pursuant to Article 42.15 Section Code of Criminal Procedure because the court is finding indigent. And based on that finding of indigence, your court costs will be waived. This case will run concurrent with cause numbers M313722 and cause number M313724. Ms. Vital, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer and court's finding is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, Ms. Vital, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Vital, this will conclude these 3 cases. And Ms. Vital, before you leave, I need to give you an admonition pursuant to Article 1.76.1 of the Texas Administrative Code. Mr. Cole, could you give that to your client and I'll go over that with her? Ms. Vital, you just been handed a document that is titled Model Written Admonition on Ineligibility to Possess Firearm or Ammunition. Do you see that title?
Yes, sir.
And I will go over this document with you. And it states, in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you of the following. Number 1, you are my ammunition. Number 2, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number 3, under Texas Penal Code Section 46.013, A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that have as an integral part a folding knife blade or other characteristics, a weapon made illegal by Penal Code Chapter 46, and that is 1, an antique or curio firearm manufactured before 1899, or 2, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, Section 46.02, unlawful carrying weapons. Penal Code, Section 46.04, unlawful possession of firearm. Penal Code, Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code, Section 85.026, warning on protective order. Now, Ms. Vital, that ammunition that's in your hand, that's for your records. You're gonna stand on the X next to your attorney and follow the directions of our clerk. Once you finish following his directions, you'll be free to go and you have a blessed day.
Do you know where to turn yourself in?
Yes, sir.
Jefferson.
County.
On 69, right? All right.
Thank you, my big excuse.
Yes, you may be excused.
So could I have one of those papers that you just gave me, please?
Oh,
Copy.
yeah.
Yeah, how far? Appreciate you, sir.
Drew, you have a case in this court, and it's our understanding that it doesn't show that you have an attorney representing you in this court. However, now as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. That's number one. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number three, you may waive your right to an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to have an attorney and represent yourself, you cannot speak to the prosecutor unless you first sign a waiver of a written waiver. And a written waiver is the second page that's on the clipboard that is before you. Okay? Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service. Was that, huh?
I was running the church and I had time.
You do.
Okay, yes, yeah, but I hadn't got there yet.
Oh.
Okay, so I'm just telling you, you have a right to hire an attorney, see if you want one appointed or represent yourself. Now, as I mentioned earlier, He's the prosecutor who's handling the case. You can't talk to him unless you first sign a written waiver. If you want to waive your right to have an attorney and represent yourself, then you can sign a written waiver and then you can talk to the attorney about what they're offering in the case. Now, the other thing is that be aware that the dangers of self-representation, waiving your right to an attorney and representing yourself may result in the worst outcome for you, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you can change your mind at any time and request that an attorney be appointed to represent you. Do you understand that? What that means is that, let's say you waive your right to an attorney, you're representing yourself. Then you talk to the prosecutor. If you don't like what the prosecutor is saying, you can say, well, Judge, I want an attorney. You understand what I'm saying? In essence, you'll say, Judge, I want an attorney appointed to represent me. And then you would have to fill out a form, and we make sure if you qualify for court-appointed attorney, we'll appoint an attorney to represent you, okay? So I'm saying at this point, you have three options. You can hire an attorney, so that's number one. Or number two, if you do not, if you cannot afford to hire an attorney, you can ask for an attorney to be appointed to represent you. Or number three, you can simply represent yourself by waiving your right to have an attorney.
Yeah, if I represent myself and I don't like what he offering or whatever.
You can change, that last paragraph says, you can change your mind and request that an attorney be appointed to represent you. Okay, does that answer your question? Okay, now at the bottom of this document, it says defendant's choice, mark initials next to only one choice. If your choice is to have your case reset to hire an attorney, you place your initials on the first line to the left. And then, or if you hired an attorney already and you haven't, then you will place your initials on the first line, on the second line to the left, and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, which you haven't, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you finish initialing one of the 5 lines, then you'll sign on the document that is titled Defendant. You sign your name there, and you will date it today's date, June 14th of 2023. Now, do you understand? Okay, so we'll give you some time to make your choice. The second document, which is waiver of counsel for purposes of entering a guilty plea or proceeding to trial, it says, I have been advised of the nature of charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 14th day of June of 2023 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you're going to sign your name on the line where it says defendant, and you're going to date it today's date, June 14th of 2023. Okay, thank you. Mr. Drew, I have before me, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that is titled Defendant?
Yes, sir, Your Honor.
And are these your initials on the line saying you want to waive your right to attorney and represent yourself? And also, I have a document that's titled Waiver of Counsel Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, before you sign any initial these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? So at this time, Mr. Drew, he has two cases. Yeah, and you have two cases. In these cases, Mr. Drew, the court is going to allow you to talk to prosecutor in this case, Mr. Colby Hoffpar. And you want to
Want
talk?
to do that here, doesn't, or we want to take him out and you stay or whatever you want. We can go back.
Yeah, you can go to